Our second case this morning is 2019-923 In Re AM for the appellant, Ms. Daugherty. You'll have to unmute your microphone. Ms. Daugherty, unmute. We can't hear you. There you go.
Thank you.
Proceed.
Chief Justice O'Connor, may it please the court, I'm Cynthia Daugherty, counsel for Brianna Dickerson, mother of AM. I would like to reserve 3 minutes of my time for rebuttal. In parent termination cases, Ohio law requires the juvenile court to consider all relevant factors, including the mandatory best interest factors contained in Revised Code 2151-414 D1A through E, before terminating parental rights as required under Revised Code 2151-414B. We are here today to determine what it means to consider and whether consideration requires some written discussion as to what facts and evidence the court used when considering each factor. In order to properly consider all relevant factors and each of the best interest factors, a written discussion is necessary. In this case, the trial court failed to provide such discussion on an important factor pertaining to the relationship between AM and mother as required by 414D1A.
So, Ms. Daugherty, in this case, there was a magistrate's report, and then your client had an opportunity to file objections. Did your client object and say that the best interest factor wasn't discussed?
I believe so, yes, her trial attorney.
So they made that objection?
I believe so, yes.
Are you sure?
I'm not sure.
What if she didn't? What would that mean?
Well, I think if we look at the independent review of the judge, it is the same situation where there isn't any reference as to the evidence that was used to make those determinations. It looks like a page and a half. So I would say, given that the judge's review is lacking in that sense as well, that we could proceed this way.
Well, I mean, isn't the point of objections to a magistrate's report is that if there's a problem, let's point it out to the judge and they can fix it now, look at that factor rather than having to deal with it on appeal?
Well, it's the same issue that I'm raising here about the judge's review, that it was lacking in the analysis as well. And I think we may be able to look also to what the court is currently doing. The court in Hamilton County is actually making these changes and putting in these best interest discussions.
Counsel, on 2151.414D, it says the court, quote, shall consider, close quote. But in 2151.419B1 says the court, quote, shall briefly describe in the findings of fact, close quote. Or in 2151.28L, the court, quote, shall include in findings of fact and conclusions law specific findings, close quote. If the legislature wanted to say findings must be written down, couldn't it have just said it?
Yes, I think in that sense you're correct. However, it's even more confusing to everyone when there is some discussion in a few of those factors and no discussion in other factors within those same mandatory factors. How do we know that the missing considerations were actually looked at or considered? So in this case, we have 3 factors with some writing or discussion, and we have 2 that have nothing. So the court makes it a little more confusing if you don't have a based on the way the magistrate was writing her decision. It would seem that it's either one or the other, but to assume that she found nothing in the relationship between mother and AM when 414D1A actually is asking for what the interaction and interrelationship between parents and children are, then I think that there's evidence in the record and testimony at trial that speaks to that, directly speaks to that relationship. And we're absent that consideration. So how we can come to a determination that all those factors were considered, how do we know they were considered?
Counsel, had the magistrate recognized the bond between AM and her mother, would that have made a difference here?
I believe it would, Your Honor. I think that mother
In
had,
light of the other findings, you think that that would have trumped the other findings?
I think that the courts has determined that no one factor gets more weight than the other, than the others. However, we have two that are missing in analysis and facts to that law. And I think it would make a difference if we go back and look at that. I think the court has said that the parent-child bond is extremely important.
Granted, but with all the other findings and the failures of your client, you know, with the reunification and, you know, what she was mandated to do, you think the fact that the mother and child have a strong bond would have countered all of the other three factors that weighed in favor of the judge's decision?
I do, because one of the factors which I did not raise was that there was more time. She was not in the custody 12 to 22 months, but the other issues are that mother.
Are we talking, is that before us, what you're talking about now?
That I did not raise.
Okay, so we're not considering that. So we're just considering what you're saying is the child enjoyed being in the mother's company.
Yes, but in spite of all of mother's obstacles, in spite of everything that was thrown in front of her, and in spite of her history in the past and the fact that she was a minor mother, struggling by being in the custody of the agency at the time as well, in spite of all that, mother made a bond with the baby. Mother continued to visit, and the only reason her visits were ever canceled had to do with when she emancipated, her Medicaid stopped and she had to reinstate that. And then she missed visits due to her work schedule and they were reinstated by the agency. So there was never any issue with mother's bond with the baby, with AM. If you look at the 4D1A, it does consider the interrelationship between AM and mother. And there was testimony in this record about that relationship. But the other part that's missing is the 414D1E, which considers whether any of the factors in 414E 7 through 11 apply as the relationship to the parents and the child. It differs from the actual interaction and interrelationship between the parent and the child as is considered in D1A. So that other factor, that D1E, this is where the magistrate applied facts to that law that don't even apply to anything in that law. So applying 7 through 11, which speaks about is there any plea of guilty under certain enumerated offenses, whether the parents withheld medical food or care, whether the child was placed at risk due to drug or alcohol abuse, whether the child was abandoned. the magistrate didn't speak to that in those issues. She spoke to visiting issues, which I already touched on, and an altercation between mother and father in 2017. So we still don't know if the magistrate actually considered E, factor of D1E. And the actual writing that she has in section E would indicate that she did not consider that. It would support her not considering it. I mean, this is about a mother who at the time of AM's birth was 16 years old, herself had been in care, in the agency's care since the age of 13. Mother was very young and truly had a difficult life, as you can see in the facts section of Mother's brief, both prior to and while in the care. Mother was placed in several foster homes and a residential facility. Mother reported being raped by a foster father when she was 15 years old. And the rape was such a traumatic event. The court should have given Mother more time. When Mother was 16, she began being involved with AM's father and gave birth on November 10th of 2015. Mother did complete a residential program. She began her permanent plan living arrangement, and she also had drug screens and parenting classes. So Mother did guys and girls off drugs. She reached out and did some programs on her own. After she left residential treatment, it took the agency 5 months to get her follow-up care. All throughout the case, the agency filed their reports to the magistrate months late. One of them was even 5 months late. And Mother, as a minor, had a GAL appointed, and that GAL never filed one report as to what's in the best interest of minor Mother at the time. So in spite of all these obstacles, moved around, not only prior to coming into care, while in care, Mother still maintained a bond with this baby. I think to look at the due process requirements and the consideration there, we have to look at the interest of the parent and her liberty right to raise her own child, the risk of an error being presented by a lack of a written discussion when considering those best interest factors, and the cost and the burden on the state to add this requirement to have a discussion, and the interest of the government in the effective adjudication. And if there's no other questions, I would like to save the remainder of the time.
Let me, I do have one question. You're advocating for a rule that says in every case, there has to be an explicit discussion of every best interest factor. What about a case where, you know, a couple of the factors really aren't an issue, and the case really turns on, you know, a very important factor, and the magistrate writes about that, analyzes that, and doesn't talk about something that's not important. It's not an issue.
I think that the consideration should equal a discussion. I mean, that is how we do law.
That's not really how we do law, right? I mean, generally we do law we focus on what's important. You know, we have statutes all the time that's, there may be factors that don't matter, so you focus on the factors that matter. I mean, why shouldn't that be the rule?
Because we don't have a way to know if the magistrate considered all those factors, which is required by the law. And I think that if we consider this parent termination in the way the court has handed down that it's a civil death penalty for parents, then in those death penalty cases in the sentencing stage of it, at least there is factors that are considered, and the statute uses the word consider, to where it also equals a writing, a separate writing and opinion about what was considered in those mitigating factors. So,
Counsel, was there any dispute that the child, AM and Brianna, had a good relationship?
I don't believe so.
Then what's the controversy here? To Justice DeWine's point, that's a given.
I'm sorry, I'm not understanding what you're asking.
if there's no dispute that Brianna and the mother or the child had a bond, what's the dispute that, why would that be a factor that would have to be expounded upon by the magistrate?
Because that's the first factor that the legislature put in there as part of the best interest analysis. When they determine the best interest of the child, that's one in there. And the juvenile courts are courts of best interest. So that is the main focus, as in Cunningham, that it is, those best interest factors are in both analysis and both those pathways to go to permanent custody.
Is the problem here that the magistrate didn't discuss a factor, or is the real problem here is that if you read this decision, it just doesn't seem like there's any real weighing or thinking about best interests at all? I mean, there's no, it's almost devoid of analysis. I mean, isn't that what we should worry about? Not whether or not there is a checklist of factors that were mentioned?
I think, yes, you're right that it does seem like it's void, but I think to just assume that there is nothing there and that the magistrate considered it because it's absent some consideration or some discussion about the consideration is not the way to go. I mean, wouldn't it be better as a policy if we could say to parents, here is what you did wrong, even if they are wrong. And if it's not, there's a way to challenge what the magistrate considered if we're missing a discussion about the evidence, as in this case. We're missing that critical piece in A1. I'm sorry, 1A. And if there's no other questions, I believe I'm over time.
All right. We have Mr. Varney first.
Yes, Your Honor. Good morning, Your Honors, and Chief Justice O'Connor, may it please the court. Nicholas Varney, representing Hamilton County Jobs and Family Services. Your Honor, in the present case at bar, we contend that the plain language of the statutory section at issue here, 2151D, is unambiguous, and as such, there's no need for a court to interpret the language of that statutory section, and the court must apply the statute as it's written. Here, 2151D states in pertinent part that the court shall consider all relevant factors, including but not limited to, and then it goes on to list the best interest factors that the court need to consider. I'm sorry.
If the language is that the trial court shall consider, how is an appellate court, in order to provide meaningful review, if there's no discussion of the facts in the opinion, is it enough for the trial court to just simply repeat that statutory language that it did consider it, and appellate courts have to assume that they did if they state that?
Certainly, Justice Donnelly, I think maybe a more robust discussion of how the court considered and used the facts and evidence and in the record to arrive at their decision would be helpful. And in fact, the First District in its majority decision said that it would strongly urge the juvenile court to do more of a discussion, but it could find no fault with the court's ultimate decision here, given that the facts and evidence and in the record and that were presented at trial supported the finding that the magistrate ultimately made. All right.
Well, given the Supreme Court's part of our duties to provide guidance to the lower courts, wouldn't it benefit both sides, including your side, to require at least, maybe not address any checklists that are items that are irrelevant, but at least require trial courts to provide some discussion of what they found credible, what they weighed, persuasive? Wouldn't that help everybody involved?
Yeah, Justice Donnelly, I completely agree with you on that. And I think to Ms. Doherty's point, I think courts are starting to do that now. I certainly wouldn't present this magistrate's decision to the court and say this is the best decision that anyone has ever seen. But I would agree with the First District that when taken in totality, when reading the entire decision, which the juvenile court did and the first district did in its review, ultimately the findings that were made and the decision that the magistrate made was amply supported by the evidence and by the record. So I do not disagree whatsoever. I think courts can always do the best job that they're able to in giving parents and the agency and other litigants as much information as they possibly can should something be appealed or reviewed by a judge. So I certainly don't disagree. But given that, I would again just state that the first district, while it did indicate to the juvenile court that it would be best practice to discuss more, it couldn't find any fault with the juvenile court's ultimate findings, and that's why they affirmed.
Mr. Varney, I appreciate your candor about the failings in the magistrate's report. I mean, really what happened here was, if you look at the magistrate's report, there's really no analysis. And the Court of Appeals went back and did the analysis on its own. It went through and said, okay, here's the record, here's what we have, and this supports the decision that the magistrate did, and essentially wrote the report that the magistrate should have written. Which is fine in a way, but what concerns me there is, in that situation, how does the litigant have a chance to object to the Court of Appeals findings, right? If the magistrate made findings, the litigant could object. But if it's the Court of Appeals that's doing that, as happened here, how does the litigant get to have a chance to object and say, no, these findings aren't correct that you're making?
Well, and I believe, Justice DeWine, that that's why we're in front of this honorable court this morning, just for that reason. Certainly, having the first district do essentially the work of the magistrate in juvenile court kind of makes the appeal process a little bit more difficult. And like I said, I am hopeful, as I believe all of my colleagues in juvenile court are, that the decisions that are being produced in juvenile court today are much more robust than the one that's before the court this morning. That brought us to this point. So I think that there is some serious concern, Justice Wine, that if decisions like this were to be more common, or the first district were essentially playing cleanup for the magistrate's decision, that it would prevent litigants with it to have a cognizable chance at a meaningful appeal. But again, I do think that this case, again, while the decision is not the most robust, the court got this right. I think that the court found that the best interest of AM was served by placing the child into permanent custody. And I think, again, a point that I made earlier that struck me as I worked on this case was that the record has to be taken as a whole in these cases. Dependency cases span months and years, and there's a litany of evidence in the court's record that it must consider when making a decision at the end of trial when posed with a motion for permanent custody. And that includes status update reports, review reports, reports by guardians at LITEM, reports by Jobs and Family Services. And I believe that the magistrate considered all of that information when making this decision.
Counsel, if you look at the Court of Appeals opinion, paragraphs 20 through, I think it's 25 or so, there's a recitation of the findings of the magistrate and then affirmed by the Court of Appeals. And there's a whole litany of shortcomings. The mother's failure to meet all of the, I guess, reunification plan milestones that, and there's no dispute that this was true and it came out at trial. She uses marijuana. She doesn't think that she needs to stop using marijuana. She's not participating in the programs that were laid out for her, et cetera. I mean, it's all laid out there in the 4 or 5 paragraphs there. Then you balance that against the fact that there is no, I guess, in the appellant's view, no appropriate emphasis on a factor such as the child and the mother get along well together, that there's a bond there. And my question, previously asked, would that have trumped all this? Would that have made a difference? Is that, so significant that the magistrate, the trial court, and the Court of Appeals should say, well, clearly that's going to, change and make up for all the, other findings that are in these paragraphs?
Chief Justice, I don't think that specific finding of a bond between AM and her mother would have overridden the other considerations that the court took into account that you just listed. I've practiced juvenile law and dependency law my entire legal career, and I was previously a guardian at LITEM. Excuse me, and I can say that most children, if not all children, have a bond with their parent. And I believe that absent really extreme circumstances, that evidence is going to be presented at trial. Of course, the child had a bond with her parent. However, the child was very young at the time of this trial, and any young child who is being cared for by their parent is going to enjoy that time. But as you indicated, there was a mountain of other factors that weighed against mother being able to get a remand of this child into her custody and care for this child. I think that the evidence weighs incredibly heavily towards the fact that mother was not an appropriate parent, regardless of whether she had a bond. So I don't find that fact to be dispositive at all, Your Honor.
But counsel, aren't we required to just speculate on that fact? Wouldn't it have been better for the magistrate to say this evidence was presented and I found it credible or not credible? But regardless, the way it comes out in the end, it doesn't trump. And it had that discussion. Yeah, that would be better for both sides, right?
Certainly, Justice Donnelly, I completely agree. And most decisions that we look for at the end of permanent custody trials would have that consideration and that discussion in them. So I can't argue with your point there whatsoever. So just to wrap up, because I think I only have a few moments left, touching on due process, in the agency's opinion, mother's due process rights were not violated here in this case. She was afforded counsel. She was present at the trial. She was served with the pleadings that were filed by the agency. She participated in trial preparation with her attorney. She testified on her own behalf, and she appeared and participated in the trial. So this information that the magistrate, albeit in a disorganized manner, presented in the entry, mother was aware of all of those factors because she was at the trial, and I believe that her due process rights were exercised in that way. And I think with that, I'm out of time. I would like to cede the rest of my time to the guardian ad litem.
Thank you. Is it Ms. Weingartner? You'll have to unmute.
I apologize. Good morning. Chief Justice O'Connor, may it please the court. My name is CELIA KLUG Weingartner, and I am the attorney guardian ad litem for AM in this case. As AM's attorney guardian ad litem, it is my position, and today we are asking this honorable court to uphold the First District Court of Appeals decision, uphold the decision of the Hamilton County Juvenile Court that grants permanent custody of AM to the Hamilton County Department of Jobs and Family Services. As AM's guardian ad litem, it is my position that permanent custody is in AM's best interest, and it is in AM's best interest that this court apply the statute as it is written and not interpret the statute. I would submit to the court that in this case, as the agency presented, and I completely agree with this, is not the gold standard magistrate's decision here. It is not the gold standard of the way it should be written. I would submit, though, that all of the factors were considered when you take in light the whole record. Appellant relies heavily on the interrelationship factor, bond between mother and child. The agency touched on this a little bit, but I would submit to this court that most parents involved in permanent custody cases have a bond with their children. In most cases, that bond is going to exist. In this particular case, I believe it did, but as previous counsel said, it is not just positive in this case. The best interest factors are not a checklist to go through determining which ways in favor of a parent, which ways in favor of a state needs to be considered as a whole and weighted. In this case, I submit to this court that it was weighted, and it did weigh in favor of permanent custody being granted to the Hamilton County Department of Jobs and Family Services. Would note as well and submit to the court that this is only the second part of the analysis. The best interest factors come after the first finding of facts in the permanent custody statute. And there's no argument, there's nothing being contested that that was not successfully met to grant permanent custody of AM to the Hamilton County Department of Jobs and Family Services. Would also note for this court that this court and no other court in the state of Ohio has ever held that it was necessary for a discussion. We would be asking this court to apply the plain language of the statute, which says consider, as opposed to interpret the law and change it at this point. I would also present to the court that if this court thinks there should be a requirement for discussion, that it should happen through the Ohio legislature as opposed to this honorable court. I would also submit that if the court views the appellant's argument to be persuasive and rules in favor of appellant, that the proper remedy is not a remand of custody. It is not a dismissal. It is not a new trial. It is a review of the entire record in this case and a rewrite of that decision to demonstrate a consideration. As the first district, I believe, has done before in re-KT.
Counsel, do you think it's appropriate for the appellate court to, first let me ask, how does an appellate court review a decision like this by the magistrate and by the juvenile court? And is it then appropriate for the appellate court to actually set forth the analysis?
Your Honor, are you asking if the first district should set forth the analysis, or if
first, how does an appellate court review a magistrate's decision or juvenile court's decision saying we've considered all of the statutory factors? Is that statement enough?
Your Honor, my belief there is that you can review the whole record in this case if you were to determine that was the right way, meaning reading the trial transcripts, reviewing the reports that have been submitted. As counsel discussed, there's more to this than just a trial, and take all that evidence in light of the entire record, and from there rewrite a decision showing consideration.
Did you say rewrite a decision?
If that is the remedy that this court saw fit, if they were to rule in favor of appellant.
So doesn't that, if what comes from the trial court, nothing more than what was sent up in this case, or a mere statement that we considered all the factors, the statutory factors, then could the appellate court do the same, consider the factors, and come to a different conclusion?
I believe they could, Your Honor. I mean, that is the purpose, in my opinion, of an appellate court. If they were to review the whole record and think the magistrate made the wrong decision, I believe they could do that.
What's the Court of Appeals standard of review?
At this point, they're looking for error in general, Your Honor. I don't found it.
For legal error and de novo review?
Yes.
There's no there's no discretion on the part of the trial court in how these factors are weighed?
Are you referring to the judge or the magistrate, Your Honor?
Well, if the magistrate conducts the trial or the hearings and the judge, the juvenile court judge, signs off on the magistrate's decision, which ultimately has to happen for there to be a final judgment.
Yes.
Then what comes up to the appellate court, assuming the juvenile court judge did nothing more, what the Court of Appeals does is review what the magistrate decided.
Yes.
Correct?
That is correct.
And so then if the appellate review is, if the appellate court reviews an order that says, upon review of the statutory requirements, we find it's in the child's best interest that permanent custody be awarded to the county, then what happens next? The appellate court should essentially rubber stamp that, Or is it up to whoever appeals, the appellant in that case, the parent, to say, well, this decision didn't make sense because there were more factors that weighed against permanent custody? In other words, is it the appellate court that should undergo the analysis as what happened here? Is that the appellate court's job?
I see what you're saying. No, Your Honor, I do not believe that's the appellate court's job. I think that's how we ended up before you in general. I think it is their job, though, to take in light the whole record and make a decision about whether the correct decision at the trial court level was made. And I think they did that here.
But I guess in these facts probably, are not the best ones granted. I guess my problem with that is if it's a close call by a weighing of the facts, if it's a close call after appellate court weighs the facts, then one would say you have to affirm the trial court's decision. But, if it's not a close call after weighing those factors, then you'd have the appellate court reversing, I don't want to use the term substituting its judgment, but essentially that's kind of what would happen.
I see what you're saying. In this case, I believe the factors, as previous counsel said, do not weigh in favor of appellant, which led to the uploading. I get what you're saying, where there may be a concern in a closer case. Here, though, I don't think there's any evidence that the trial court erred as a matter of law.
Thank you.
Thank you.
Ms. Dougherty? I'm trying to see how much time you have left. I think you've used your time, but you may take a minute.
I just wanted to make it clear on the court that our district did have a case where they, following the two cases in KT in August of last year, 2019, where that first district did reverse and remand with instructions to consider the best interest and discuss them with specificity. So to give the notion that our district, first district, has not looked at this and said we need more. And I think that these best interest factors and the fact that this is considered a civil death penalty, that we do need more. And that court also does that. That was in August of 2019, and that was the case of NRA BK children. My client, of course, what we're doing in the courts now doesn't help my client. I think that if the case could go back, it would be difficult for this to have just a review, because the magistrate that was sitting in this case is no longer on the bench, and being the best trier of facts, able to see the witnesses and discern everything, I think it would have to be a new trial. And with
Thank
that,
you. We'll take the matter under advisement and we'll be notified of our decision.
Thank you, Your Honors.
thank you.